Hi, welcome back to the Constitution in a Nutshell. I'm Ron Turner. I'm glad you're here. Well, today's the day we've all been waiting for. We're finally going to peek inside. It's kind of like Christmas, isn't it? We're going to peek inside the Constitution and see what it says. If you have missed any of the previous lessons, I recommend that you stop this one, go back and look at the other two, and then rejoin. This one will make a lot more sense to you. Well, as you will recall, our story will pick up in the hot summer of 1787. Shays' Rebellion took place in 1786, and that was the final straw. The Articles of Confederation just weren't working. Something had to be done. So a meeting was called in Philadelphia, representatives of the 13 states, to do something about it, to fix the Articles. Delegates from 12 states showed up, and their charge was very clear: to fix the Articles of Confederation. Well, George Washington was convinced to come. He didn't want to come until the last minute. He wasn't sure that it would be good for him to be there. Benjamin Franklin also came. He was the oldest and probably next to Washington, the best known delegate. If this sounds familiar to you, it's because there was a similar meeting that took place in Philadelphia in the summer of 1776, where representatives of the 13 colonies showed up, and they decided to declare their independence. Well, these delegates were very similar to the ones in 1776. They were all white. They were all male. Most of them were well off. They were also highly educated. We need to acknowledge that. We need to deal with it. But as I've said before, don't throw the baby out with the bathwater. Let's look at what they came up with and then talk about those other factors, which are very important. No question about it. It didn't take them long to realize that the Articles could not be fixed. They decided that they had to come up with a brand new Constitution. So that's what we're going to look at today. And I think it's interesting to start out with a quick overview. The Constitution is actually very short. It has a preamble, which is an introduction, and then 7 parts or articles, and then some amendments. And we're going to look at language for each of those, as I have done in the previous documents, the Declaration of Independence and the Articles of Confederation. I've deleted some language to make it easier to understand, but the words that I'm reading are right out of the original documents. So here's the preamble. We, the people of the United States, in order to form a more perfect union and secure the blessing of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Isn't it interesting that they said they were trying to form a more perfect union? How can something be more than perfect? I suspect this may be a reference to the fact that they were actually trying to improve on the Articles of Confederation. There were some good things in the Articles. They were trying to make them even better. Article 1, Section 1. All legislative powers shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives. Now, that's a short sentence. It basically says that under our new Constitution, we're going to have a legislature, that's the body of the branch of government that passes the laws, that has 2 chambers, a Senate and a House of Representatives. Even though this is just a few words, it represents months of debate, because under the Articles of Confederation, there was a Congress that had 1 house in it, you may recall, and each of the 13 states had an equal vote, regardless of their population. So the smaller states were very reluctant to give that up. Finally, there was a compromise. It took a while to come up with this, to have a Senate where each state got 2 senators, regardless of their population, and a House of Representatives, which was the size of which was based on population. Section 8 in Article 1. The Congress shall have power to collect taxes, borrow money, regulate commerce, declare war, and to make all laws necessary and proper for carrying into execution the foregoing powers. Now, there are about 18 specific powers listed in Section 8. I've just selected a few so you can get a feel for it. I want you to look in particular at the language to make all laws necessary and proper for carrying into execution the foregoing powers. This is the necessary and proper clause. It clearly shows that the intent of the framers, that's the people who were writing the Constitution, was that Congress would not be limited solely to what was specified in the Constitution. They had the power to pass the laws necessary to do other things, regulate commerce, for example. Section 9, the importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808. Now, if you didn't know what this was about, you wouldn't know what this is about. It's about slavery. The Constitution actually approved the institution of slavery, at least for 20 years, without using the word. It was the most emotional, the most hotly debated issue at the Constitutional Convention, and it almost split the convention in half, and everybody went home. They finally decided, we just can't come to a compromise on this, so we're going to agree that for the next 20 years, the importation of enslaved people will not be prohibited by law. One thing I wanted to mention about Article 1 before we move on to Article 2, the legislative branch was considered the branch closest to the people. Now, the intent of the framers was that they would separate power. We're going to talk about separation of power here in just a minute. Under King George, before the colonies broke off and became independent, all the power was in one person, King George, and he was a tyrant. He abused that power, and that was what led to the Declaration of Independence and a new nation or a confederation being formed. The purpose of the Constitution was to separate that power from one person or one group into three parts. The legislative part, which is the one closest to the people. The executive part, which is the presidency. And the judicial part, which is the court. So the framers were very intentional in putting Congress first, and they listed the different branches of government because that's the one that would turn over, at least theoretically, part of it would turn over every 2 years because the members of the House of Representatives were reelected every 2 years. Let's move on to Article 2. This says the executive power shall be vested in a president. Now, here again, this is just a short sentence, but it represents weeks and weeks of debate. The first question was whether it would be a president or several people would hold that office at the same time. Can you imagine 2 or 3 people holding the office of president, splitting the duties? They finally decided that was not workable. The other thing they debated was what should this person be called? Some people wanted to call the chief executive His Excellency. Some even wanted a king after all the problems they had under King George and then the new problems they had under the Articles of Confederation. George Washington could have been named king or president for life if he had wanted to. He was that popular. They kept the word president, which was in the Articles of Confederation, but they certainly expanded the powers of the president from being just a committee chairman to having a number of powers. Article 2 goes on to appoint the President Commander-in-Chief of the Army and Navy, to say that he or she will give information on the state of the Union, that should sound familiar, to the Congress annually. Article 3, the judicial power shall be vested in one Supreme Court. The judges shall hold their offices during good behavior. Now, here again, it's a short sentence. The fact that there's only going to be one Supreme Court was very important. And the judges shall hold their offices during good behavior. What does that mean? It means life, as long as they behave themselves. Now, judges can be impeached for misbehavior, the same as the president and other officers can be. But this is a very important provision in the Constitution because it creates life terms for all federal judges, not just the Supreme Court. You'll also notice that the size of the court is not established in the Constitution. Congress can increase or decrease the number of justices at their will, and they've done it. I'm not remembering the exact numbers, but I know the smallest was probably about 5, and it may have got larger than 9, which is the current size of the Supreme Court. Now, there's one more concept I want to talk about in some detail before we move on to Article 4 of the Constitution, and that's separation of power and checks and balances. I want you to think about the 3 branches of government: Congress, the presidency, and the courts. As I said earlier, the purpose of the framers in creating 3 branches of government was that the power of King George, vested in one person, would be separated so that the potential for abuse would be reduced. And they did that in 3 branches: the legislative branch, which passes the laws; the executive branch, which then sees that the laws are carried out; and then the judicial branch, the courts, which interprets the laws when there's a misunderstanding. Under the Congress, one of the powers they have, now we're going to talk about that checks and balances. Separation of power is pretty clear. You separate all the power from one person into 3 branches. And then you have checks and balances, which means each of those 3 branches can check the other one if they start abusing their power. What does check mean? If you're a hockey fan, and I know very little about hockey, a check is a defensive play in hockey where one player tries to block another one. Okay, so if one branch of the government sees another branch abusing its power, there are ways that branch can block the second branch. For example, Congress has the power to pass bills or to override veto of bills. What is that? Well, the president can sign a bill. Once Congress passes a bill, they send it to the president, who has the power to sign it, which means he or she will approve it, or veto it, which means they don't agree with it. They send it back to Congress, and Congress can then override the veto and pass the law anyway with a higher vote, usually 2/3 or sometimes 3/4. So that's a check and a balance that Congress and the president have on each other with regard to the passage of laws. How do the courts have a check or a balance? Courts can find laws unconstitutional. Now, a court can't just do that on their own. They can't just dream up an idea and say, hey, I think that's unconstitutional. Someone who has standing, some citizen, has to file a lawsuit saying, I think this law violates the Constitution. And if the lawsuit goes all the way up to the Supreme Court, the court can find the law unconstitutional. Actually, a lower court can find it unconstitutional, but it would be appealed and ultimately go up all the way. What's another power that one of the branches has? The president has the power to appoint federal judges. But when he makes an appointment, they send it to the legislative branch to be confirmed or rejected. And I'm sure you've seen many hearings on television. They go on for days here lately, where the president wants someone to be appointed to the Supreme Court or a court of appeals. And Congress has long hearings where they ask all kinds of questions. That's a check and a balance. The president appoints the judges. The Congress can either approve or reject them. Once they're approved, then the judges are on there for life. That's one reason the legislative branch is so careful about approving the appointment by the president. Another example of checks and balances is that Congress can impeach the president and other officers. And being impeached means that the charges have been filed against them in the House of Representatives. Once that happens, then there's a trial that takes place in the Senate to see if they actually are guilty. That's a 2-stage process. Impeachment does not mean removal from office. Impeachment means that they've been charged with high crimes, misdemeanors, and then the issue has been sent to the Senate, where the Senate actually sits as a jury with the Chief Justice presiding. This is a perfect example of checks and balances. The president can be impeached by Congress, then by the House of Representatives. Then the Senate has a trial, and the Chief Justice presides over that trial. The final example of separation of power and checks and balances I want to talk about is declaration of war. Only Congress can declare war. Now, that's gotten very messy in the last 50, 75 years because Congress has authorized the president to take military action without an actual declaration of war. But under the Constitution, before the United States goes to war, Congress has to declare the war. Once Congress does that, the president becomes the commander in chief of the Army and Navy. Now, remember earlier in Article 2, the president was appointed commander in chief of the Army and Navy. What about the Air Force or the Coast Guard? There are some people who say that you should read the Constitution exactly the way it's written without any change whatsoever. Well, that would mean that the president is only commander in chief of the Army and Navy. That would be crazy. Wouldn't make any sense. Obviously, you have to use some common sense when reading the Constitution, and this is a perfect example. Another point to talk about here, it was very important to the framers that the person over the military be a civilian and not a military person. They were concerned that if there was a general who was very popular, the army would follow that general. The general could stage a coup, which is a takeover of the government, and democracy would be out the window. As we know, military coups take place all the time around the world. The United States has been pretty lucky in the last 240 years that it hasn't happened. One big reason it hasn't is that the president is the commander in chief. Now, many of our presidents have had military experience and military backgrounds. When they're serving in the position of commander in chief, they're serving in a civilian capacity. How do the courts get involved in war as far as checks and balances are concerned? Here again, if someone challenges a war saying that it's unconstitutional or illegal for whatever reason, the court can find that that's true or not. That's how they can check and balance the action by Congress and the president with regard to the war. Well, I think that's probably enough today. Before we move on to Article 4, I want us to take a break, digest everything that we've talked about today. I know I've given you a lot. If you like what you're hearing, please subscribe to my channel by clicking below and send me some comments, positive, negative, or otherwise, of ways I can improve this series. And if you would share it with friends of yours, that would be very much appreciated. I'll see you next time. Take care.